So, friends, can we talk for a few minutes about the currently dismissed criminal prosecutions against James Comey and Letitia James? It's curious. Those cases were dismissed going on 2 weeks ago now, and the Trump administration, the Department of Justice, hasn't filed notices of appeal for those dismissals, nor have they filed new indictments against former FBI Director James Comey or current New York State Attorney General Letitia James. And it just might be because they are struggling to find a lawful way to re-bring those cases without them just being dismissed a second time. I just sat down with my friend and former Palm Beach County State Attorney Dave Aronberg to talk about the many hurdles, the many obstacles facing Donald Trump's dirty DOJ leadership in re-bringing those cases against James Comey and Letitia James. I hope you enjoy this extended conversation with Dave Aronberg. Let's get started. We have our friend Dave Aaronburgh back with us. I'm sure you know him, if not from his own Substack, which is growing by leaps and bounds. And I hope when you're done here today, kind of click over and give him a follow, subscribe to his Substack channel. You probably know him from Morning Joe on what was MSNBC, is now MS Now. He's a regular. You can see him on there often, several times a week, giving great legal analysis. He is the former state attorney for Palm Beach County. His jurisdiction included a little resort known as Mar-a-Lago. He also was a longtime member of the Florida State Senate, and now he's kind of 100% independent in doing some of the private practice thing, but he's just out there as a justice fire breather, kind of fighting for the rule of law, fighting for the Constitution, fighting for justice. And, he's one of the he's an integral part of our independent media landscape, which we need now more than ever. So, Dave, thanks for jumping on with us.
Thank you, Glenn. It's great to see you and Team Justice. Thank you for the nice comments. Hello there. And let's get talking. I actually think there's more optimism than you do. I know we always talk about that. There are always signs of light, some silver linings, some victories out there. We can find them.
Yeah. So let's take on the status and the direction that we believe the James Comey and Letitia James cases are heading. And I realize, Dave, as I say that, I probably shouldn't call them the James Comey and Letitia James cases because there are no cases. They have both been dismissed. And interestingly, the Trump administration, the DOJ, has not yet filed a notice of appeal in either case. Now, I understand under the rules, they have 30 days. So literally the time to file a notice of appeal would expire on Christmas Eve. Maybe they're waiting to deliver, a lump of coal to James Comey and Lindsay Halligan, vindictive folks that they are. Maybe they'll drop it on Christmas Eve. We'll see. But right now, there are no cases. Now, we suspect, and we've heard some reporting, that they may be re-bringing these cases in the near future. But Dave, I want to unpack some of the impediments to successfully re-bringing these two indictments. And there is a really recent one. So let's start with that. You and I were talking about this offline recently. There's been a lawsuit filed by a longtime friend, confidant, legal advisor of James Comey named Daniel Richmond, a Columbia professor, former federal prosecutor himself. So can you kind of bring our viewers up to speed on the Daniel Richmond angle?
Sure. And this is an area where the guardrails are holding, where it's good news because it was clear that these cases, James and James Comey, were vindictive in prosecution. But the court didn't even have to go there. Instead, there was yet another reason. It's like choose your own adventure. Which way do I go? There's so many reasons to dismiss these cases. And the Judge Curry, dismissed them because the prosecutor, Lindsay Halligan, was improperly appointed. So obvious. Glenn, there are a lot of difficult choices judges have to make. This was not one of them. This was an easy one. And now it's up to the Trump administration to appeal that ruling. But I think they realize that their goose is cooked on this one. That's why they have not filed an appeal. That's why they're not headed towards the Supreme Court on it. Instead, they're going to refile the case because under the judge's ruling, it was dismissed without prejudice, meaning you could conceivably refile. Now, when it comes to Letitia James, yes, they could refile that. But when it comes to Comey, not so clear whether you can refile it because the statute of limitations have expired. As you know, there's this 6-month grace period where prosecutors can refile a defective case. But this is not just like a defect in the pleading. This is a prosecutor who is not allowed to be a prosecutor, not allowed to be U.S. attorney. So I don't think you should be allowed to get a 6-month grace period. That's gaming the system. But that's the direction they're going to go. They're going to refile both cases, not under Lindsay Halligan's name, but under the name of a career prosecutor who we don't know yet, probably from another circuit, because no one in that Eastern District of Virginia's office wants to put their name on this clunker of a case. And now you mentioned Daniel Richmond. So when it comes to James Comey, his bestie was Daniel Richmond. Daniel Richmond was a law professor, was his lawyer too, and a confidant. So he got him hired at the FBI when he was the head of the FBI. He got him hired as a special government employee, and he would bounce things off him. And occasionally he would talk to him about certain things that happened. And then after Richmond left the office, he then spoke to the press about certain matters. Okay, so that's the situation. Now, when the leaks about the Hillary Clinton email came out, remember, James Comey's worst moment, I think, is when he brought back up the whole Hillary Clinton email stuff right before the election. It cost Hillary the election. Oh, terrible. And then there was an article that came out in the New York Times that went inside as to what happened. And it was a leak. And so the FBI investigated it. It was called Arctic Haze. And around 2019, they subpoenaed the phone records of Daniel Richmond, who they believe was in cahoots with Comey to leak this stuff. And they got his phone records. Okay, so eventually the FBI closes the case. They don't have enough evidence that Comey authorized Richmond to leak. It's done. Now, here we are in the year 2025, and the FBI is investigating Comey for the vindictive prosecution to go after him for anything. And they're saying, well, let's see, it's about leaking information about Donald Trump or Hillary Clinton's emails. And they use these emails, these messages, private communications between Richmond and Comey for this case. For this case, we're talking about 6 years later. And that's not the way it's supposed to be. When you get a warrant to get someone's private communications, it has to be for that particular investigation at that particular time. You don't get an open season where you just get to use them whenever you want for any investigation at any time. And besides, some of these communications are likely covered by attorney-client privilege because Comey used Richmond as his lawyer. So when the judge found out that these communications were used in this case to get an arrest warrant, to be able to indict Comey, the judge said, wait, this is not cool. And so now Richmond is filing a lawsuit saying you should never be able to use these emails. You should never be able to use my messages with Comey. And if he wins that, then there is no case. Then the Comey case cannot be refiled because the whole basis of this is based on emails and text messages that apparently weren't even allowed to be used in this case to begin with.
And to be clear, it looks like, based on reporting from great folks like Anna Bauer and others, even if they were able to use these emails, it looks like there is not enough of a prosecutable case that it would be successful. But we'll set that aside because
Correct.
Daniel Richmond has filed a lawsuit. He's asked for an injunction. He wants the government, the Department of Justice, to be prohibited from using this evidence that we suspect Lindsay Halligan not only presented to the grand jury, but presented it in addition in violation of attorney-client privilege. And let me tell you, all of the literally decades I spent presenting cases to federal grand juries, privileged information, whether it's attorney-client privilege whether it's doctor-patient privilege, there's an executive privilege, there's a spousal privilege for private spousal communications. It is verboten to be presented to the grand jury. In fact, what we call it is incompetent evidence. It's designated not just inadmissible, incompetent evidence before a grand jury because privileges are sacrosanct. So that is yet another potential reason that a Comey indictment could be dismissed if it was refiled, because that issue has not fully been litigated. And how many other motions to dismiss are there? Let us count the ways. There's vindictive prosecution, there's selective prosecution. Um, so it's kind of an interesting question whether they will just fumble forward and try to re-indict Comey, or whether they will actually try to appeal the Comey dismissal. And either way, though, Dave, do you agree with me? They're still going to have a statute of limitations argument that they may not be able to overcome, regardless of which approach they take.
Totally agree. This case is dead man walking in that you could dismiss it on vindictive prosecution. It's clear. Selective prosecution, as you mentioned, the improper appointment of Lindsay Halligan, the use of attorney-client privileged information that should not be used. And you're right. Even if you use them, it's still not a crime. Remember, the FBI had this information back then, and they said, don't have enough to charge. There is not a crime. So what changed between then and now? Well, politics. That's the only reason. Then there are other things, like Lindsay Halligan made improper arguments before the grand jury. You're not allowed to make. She even alluded to the fact that you'll hear from Comey at trial. No, he has a Fifth Amendment right not to testify. What are you doing? And so there's so many, and also it could get dismissed by the fact that they don't have any evidence. Like the judge isn't going to allow a case that's so weak to go in front of a jury. The judge cuts it off at its knees right at the beginning. That's why I said it's a dead case. The only reason why they're pursuing it is because they want to please the boss, and Trump wants revenge, retribution against Comey and Letitia James. But in the end, when they walk free, they're going to have the last laugh.
And they both Comey and James have made motions to dismiss based on both vindictive and selective prosecutions if the indictments are rebrought. And I actually think, Dave, that Letitia James has an especially compelling selective prosecution case, stronger than Comey's. And the reason I say that, and this is something that I think the prosecutors were too cute by half in the way they went about it in the indictment, because they alleged that Letitia James made misrepresentations in her mortgage application documents. I don't know that the evidence will even bear that out. But another problem is when you read the indictment, it says, well, in essence, because she applied, it doesn't say for a 30-year mortgage. I think they left that out intentionally because it hurts their case. She applied for a mortgage. I'm going to assume it's a 30-year mortgage. And over the life of the mortgage, based on these misrepresentations about whether she was going to use the property as a second home or as rental property, all of that has real problems factually. But over the life of the mortgage, she would have defrauded the bank out of $19,000. Okay, that sounds like it's a significant chunk of change, not in true bank fraud cases. We're usually talking millions and millions of dollars in bank fraud, but $19,000. Okay, I picked up my old time calculator. Over the life of a 30-year loan, do you know how much a $19,000 fraud would come out to? $52.77 a month. They want us to believe that Letitia James was willing to lie on her mortgage application documents because she wanted to defraud a bank out of $52.77 a month. We've all heard the phrase, don't make a federal case out of it. Here is the poster child for that. And the reason I say she's got a really robust selective prosecution defense is because if I'm her lawyer, Abby Lowell, and he's a darn good one, I am going to do a nationwide survey of every bank fraud case, and I'm going to say, point me to another federal prosecution that was brought for $52.77 a month in fraud. Come on, folks, that doesn't pass the laugh test.
Well said. Agreed. And they have no other precedent for anything like this. I've never seen this in federal court to go after someone with a number that low. Also, the language that they're using is this Fannie Mae language that is standard and vague as to whether you can lease your second home. And it's not clear that she even violated that because there's a contradictory language. And, Glenn, if you're going to file a criminal case, you've got to have the defendant dead to rights. You've got to have them beyond a reasonable doubt. If there's ambiguity, then it's done. That's reasonable doubt. And all it takes is one juror and the case is lost. It's a hung jury. So unless you have real proof that shows she intentionally tried to defraud the government, she knew what the language was, and she committed a fraud, then you're never going to get a conviction beyond a reasonable doubt. There are still guardrails in our system. Prosecutors have a lot of power, they have a lot of discretion, but their power is not absolute.
So let me shift gears just a little bit, still related to these prosecutions. I got a little bit of a beef with the Virginia State Bar and what they just did by way of rejecting a request to investigate Lindsay Halligan for ethical violations, for violating DOJ rules and procedures, and for violating federal law. And I want to read, they issued like a 1-paragraph declination or statement indicating why they would not at this moment investigate Lindsay Halligan. Here's what the Virginia State Bar said. They said the Virginia State Bar cannot initiate a disciplinary investigation. Whether criminal indictments were obtained through material misrepresentations of fact and done for political purposes falls within the authority of the court to determine, not this office. And if the court determines that Miss Halligan made false statements to the court and sanctions her for the conduct, the Virginia State Bar can initiate an investigation. They go on to say whether a lawyer violated federal law or agency regulations is a matter for determination by federal law enforcement and not the Virginia State Bar. Although we can take no further action, we thank you for sharing your concerns with the Virginia State Bar. To which I say, are you effing kidding me? You're punting this back to the FBI, Kash Patel, to do federal law enforcement, to do a robust investigation of Lindsay Halligan's potential violations of federal law, and you're punting it back to the Department of Justice, like the Office of Professional Responsibility, to do a robust inquiry to see if Lindsay Halligan violated DOJ's policies and procedures. What planet are we living on? Do you have the... Now, I understand why they're saying what they're saying, but does this give you the kind of agita, the kind of heartburn that it gives me?
It does, because we've seen this when it came to Rudy Giuliani, but in the opposite direction. The bars did sanction him. When the courts were slow in holding him to account for lying, the bars took away his ticket. They disbarred him. And so there is precedent. You just have to have courage to do it. Now, I am not surprised that the bars in some of the states, especially if it's a competitive state. Now, if it's a deeply blue state, that is where you find a little more courage, because it's not like, for example, Virginia is a swing state. Florida, it's a red state. So you're going to see the Florida bar or the Virginia bar sanction people in a state where they know that the leadership of the state could go after them. And it takes a lot of courage to do so. And the folks at the bar are good people, but they're not going to stick their necks out on the line. I do think if they wanted to, they could, like we saw with Rudy Giuliani.
So let's finish up with this. What do you think the next move for DOJ, for the Trump administration, is in the James and Comey prosecutions? Is it a simple re-indictment of the charges? Is it a notice of appeal and fight it up through the courts of appeal or the Court of Appeals, maybe even getting it all the way up to the Supreme Court? Is it a combination of both of those things? You know, if we had a crystal ball to look into, what do you think the direction is for these two cases?
I think for the Comey case, what they're going to do is they're going to refile it with a career prosecutor signing it, and think that that is going to be enough. Now, I still think that the 6-month extension that you normally get should not apply here. In fact, Judge Curry, in a footnote, suggested that it does not, says that the door is closed. So I think that's going to be the next issue, whether the 6-month extension that normally apply would apply here. For James, they have a better argument because the statute of limitations has not expired. But then there's the argument of, in Comey's case, if Lindsay Halligan is disqualified, then who is the U.S. attorney that makes these decisions? Lindsay Halligan is not the U.S. attorney. She's disqualified. So who is it? Now, that's where it's interesting for both the James and the Comey cases, because the Trump administration would say, well, it's whoever we appoint. We're going to appoint another loyalist. But you can't keep piggybacking on these acting U.S. attorneys. At some point, they have to be either confirmed by the U.S. Senate or approved by the judges. And in Judge Curry's order, she said the replacement for Lindsay Halligan will be approved by the district court judges. Okay, Trump's not going to listen to that. So that's another conflict, another appeal. That's why this thing is headed nowhere. It's just going to be just in the mud with all these legal issues and on appeal. So it's an embarrassment, I think, for Trump, who expected as president he could push a button and he can get his enemies taken away to the gulag. Not so fast.
And I've been saying all along that once these vindictive prosecutions are actually brought in court, they will fail spectacularly, and that will expose Donald Trump as the paper tiger he is, at least on his threats to prosecute people, because he can charge them, but he cannot successfully convict them.
Yeah, Glenn, it's a great point, because if you had a career prosecutor, someone who has the real legal chops, they're not going to prosecute these cases. You had a conservative Federalist Society acting U.S. attorney, Eric Siebert, in the Eastern District of Virginia. He refused. He would rather resign than prosecute these cases. So anyone that judges are going to appoint to replace Halligan will not prosecute these cases. The only people who would be a loyalist to Trump who could not get confirmed through the U.S. Senate because of the blue slip process, or who would not get appointed by the judges. So whoever the next U.S. attorney is going to be, it's going to be contested. So that's why I mean that this thing is headed nowhere fast.
Yeah, and I tend to agree with you. I think they're less likely to appeal Judge Curry's decision that Lindsay Halligan was unlawfully appointed, because that is the fourth instance where a federal trial court judge has so ruled. One in the Central District of California, one in Nevada, and of course, Elena Haba was also determined by a federal district court judge to be unlawfully appointed as interim U.S. attorney. And we just got the Court of Appeals affirming it, saying, yep, all of these folks are unlawfully serving in these positions. So I think they're less likely to appeal and more likely, as you suggest, to just go ahead and re-indict, because that will also enable them to moot out some of the other missteps of Lindsay Halligan in the grand jury, like presenting attorney-client privilege information and misstating the rule of law and the protections of the Fifth Amendment. So I think they could clean it up a little, but I don't think they get around the statute of limitations problem in the James Comey case.
Yeah, well, Glenn, you were a federal prosecutor. So if they do re-indict, say in Letitia James' case, forget the statute of limitations issue, they find a career prosecutor to file the paperwork, but it's still filed under the Eastern District of Virginia. And who's the U.S. attorney there?
Here's my understanding. So I served under 10 United States attorneys in the District of Columbia U.S. Attorney's Office. That included, obviously Senate confirmed U.S. attorneys, interim U.S. attorneys, acting U.S. attorneys. And when we had a void, we didn't have a presidential nominee, we would simply designate somebody who was a career AUSA in the office, like the chief of the criminal division, as acting U.S. attorney, and we still got to do the work of the U.S. Attorney's office. Now, we never had the 120-day expiration problem because, we tended to do things by the rules and by the law. So it seems to me that they're still going to be able to find somebody who would simply be the acting U.S. attorney for the Eastern District, who is a career person in that office. And, I think it's an open question as to whether that acting status is subject to attack. But I don't think what the courts will say is, listen, because the 120 days has expired, the Eastern District of Virginia still needs to do business. They still need to prosecute cases, but it may be that they are left with somebody that the federal judges in that jurisdiction appoint.
Right, exactly. And anyone who those judges appoint would say no to this disaster of a case.
Exactly. Exactly. And I like where you ended that, because that is where we find hope. They may have so bungled the procedural aspect of all of this that they're not going to be able to effectively rebring these cases, but we'll see. All right, Dave, first of all, thank you for jumping on. Second, besides on Substack, where can people find your work?
Well, thank you, Glenn. Thank you for promoting my Substack page. You've been an inspiration as I started. I have a new page, and so thank you for everyone who will come over and subscribe. Also, you can find me on Instagram at Dave Aaronburgg. Plus, I do videos for the Midas Touch Network. And I have a law firm, Dave Aaronburgg Law, in my spare time, right? So we're a boutique litigation firm in South Florida. I call myself the Florida lawman. I even have that trademark, Glenn. Not bad. I got to distinguish myself from the Florida man. I don't want to be confused with like Matt Gaetz, for example.
No, nobody would want to be confused with Matt Gaetz ever. All right, my friend, thank you for jumping on. I'm sure we're going to be doing this again in the near term as more legal issues develop.
Thank you, Glenn. Great to be with you.
All right, I'll see everybody a little bit later today.